A4 district court.
That would not be true, sir.
Oh, hold on, Mr. Johnson, please. Did you have a firearm in that motor vehicle?
Yes, sir.
Was it loaded?
Yes, sir.
All right.
Veronica Glenn appearing on behalf of Mr. Johnson. Can you please state your name for the record?
Cyrano Johnson.
Your Honor, our client would like to enter a plea.
Yeah, I have paperwork.
Should have the paperwork, but I have it.
That the paperwork?
Yes,
What are you,
I didn't know. They can.
what? What was Ken, about what? Don't listen to Ken. Get a new supervisor. All right, the plea form before me indicates that the defendant would be pleading guilty to 2 misdemeanor charges. The first is count 2 of operating while intoxicated, second offense, the 1-year offense. And then also to an added count 3, it appears, of improper possession of firearm in a motor vehicle, a 90-day offense. Upon his successful plea to those charges, count 1 would be dismissed. There is also a sentence agreement of acceptance into the 14A sobriety court program. Has he been accepted?
Yes.
He has. Okay. That's the court's full understanding of the agreement. May I have him sworn?
Right hand. Do you swear the testimony you're about to give will be the truth, the whole truth, and but the truth so help you God?
I do.
State your name, please.
Cyrano Johnson.
All right, Mr. Johnson, it's this court's understanding you're going to plead guilty to 2 misdemeanor charges. The first being the charge of operating while intoxicated, second offense. That's a misdemeanor punishable by up to 1 year incarceration, a $200 to $1,000 fine plus court costs. The court could order community service and any rehabilitative programs the court deems necessary. The court could order your vehicle immobilized, could order it forfeited, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that, sir?
I do.
All right. And also that you'd be pleading guilty to the charge of improper possession of a firearm in a motor vehicle. That's a misdemeanor punishable by up to 90 days and $100 fine plus court costs and mandatory forfeiture of the weapon or device. You understand that, sir?
I do.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 14A2 district court.
What is that?
That's City of Ipsy.
Downtown. Yeah.
Yes, downtown on
Station.
Michigan Ave.
Right.
All right. Yeah, right next to the police station. Okay. You'll be sentenced there, but then you'll be going into the sobriety court before Judge Freshour, is my understanding. Okay. All right. You understand all of that, sir?
Yes. I do.
Well, what's wrong?
Just wanted to be over with. Yes,
I know, and really this ought occurred differently since it's our court's sobriety court, but nobody's giving me instructions. I mean, because all that's going to happen is he's going to go to Judge Barr to be sent to 14A. And I don't know, particularly as I'm sitting here as a 14A judge, why he can't just go from here there. That would seem to me to make sense, but
I did.
no, somebody else has to give those instructions. Or if I could do it, I'd do it, but I can't. Okay. So you understand all of that, Mr. Johnson? All right. And understanding that, do you still wish to enter these pleas?
Yes, sir.
All right. To the charge of operating while intoxicated, second offense, how do you plead?
Guilty.
To the charge of improper possession of a firearm in a vehicle, how do you plead?
Guilty.
Now you understand that by pleading guilty, you will not have a trial of any kind.
Yes, I do.
You signed an advice of rights form at some point. Any question regarding any of those rights?
No.
No? All right. Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that.
Yes,
You understand you're giving up your right to appeal of right.
yes,
Are you on probation or parole?
no,
Has anybody promised you anything other than what's been stated here today to get you to plea?
no,
Anybody threaten you or coerce?
no.
You're doing this voluntarily and of your own free will?
Free will in the court.
And also because you believe that you're guilty of these offenses?
Absolutely.
On May 28, 2025, at the location of 15 South Washington, the city of Ypsilanti, Washtenaw County, state of Michigan, were you operating a motor vehicle?
I was asleep in my car.
Okay. Was your car running at some point?
Yeah.
Okay. Did the police come up on you or somehow or another that the police came up on your vehicle?
Yes,
All right. And after inquiry with you, you were arrested. Is that correct?
correct.
You're not challenging the right of the police to detain you and arrest you in this case, are you?
No,
All right. And after arrest, you were taken to the hospital?
yes,
All right. And was there a blood draw?
was.
And do you recall what the results of that blood draw were?
I do not.
Okay, hang on.
Yes, it was 0.159 grams.
0.159.
Yes.
All right. Sir, do you have any reason to dispute those blood test results?
No,
No? All right. And had you previously been convicted of operating while intoxicated on or about in the 14A4 district court? That would have been in the city of Saline.
no.
You saying no?
In Saline, nothing.
Okay, hold on. It could have been outside of Saline. It may have just been heard there. But you don't recall that?
Never.
Do we have anything that indicates? I'm reading from the complaint in this case, which says that his prior was operating while intoxicated on or about May 23rd, 2023 in the 14A4 district court.
That would not be true, sir.
Oh, hold on, Mr. Johnson, please.
So are you determining his location?
Pardon?
His location are you determining?
For this case, no. He's pleading to a second. And so there has to be a prior offense. The prior offense that's listed on the complaint is from May 23rd, 2023 in the 14A4 district court. Mr. Johnson is indicating no. Did you
I
write?
see one through Ipsy,
Yeah.
1482.
Right, 14A2 on that date or thereabouts?
It's probably 14A, you may have been abstracted incorrectly in 14A2. I see.
Okay, so let's do it this way. Had you previously been convicted of operating while intoxicated on or about May 23rd, 2023 in the 14A2 district court, which would have been the city of Ipsy?
Man,
Yeah.
it was in January.
But the conviction,
The conviction, yes.
the conviction, the offense may have occurred in January, but what I'm reading is the conviction date.
Yes, sir. Yes, sir.
Okay, so is that correct? If I said May 23rd or thereabouts, 2023 in 14A2 district court in the city of Ipsy, would that be correct?
Yes.
Yes, okay. On the date now, coming back to 2025 in the city of Ipsy, did you have a firearm in that motor vehicle?
Yes, sir.
Was it loaded?
Yes, sir.
All right. And where was it located?
On my hip.
On your, okay, you say you had it on your hip. Are you authorized to carry a weapon in that fashion, sir?
At the time, no.
All right. At the time, you were not authorized to carry it in the manner in which you did on that date. Is that correct?
Correct.
All right. Sir, if I accept your pleas to these cases, you need to understand that if you commit misconduct between the time of my acceptance of your plea and the time of your sentencing, that you would not be entitled to withdraw your pleas, and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Correct, sir.
All right. Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
All right. And have I complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, we're satisfied.
Court will accept the defendant's pleas of guilty to counts 2 and 3. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A2. Sentencing in this matter,
February 18th at 10 a.m. before the bar.
February 18, 2026. What time?
10 a.m.
10 a.m. before Judge Barr. Bond will continue. Counsel, what I'm going to suggest to you is maybe you contact the sobriety court to see, because I think I've been on this journey with Mr. Johnson as long as he's been in this court. We've had our ups and downs, and I can understand him wanting to get it over with. It's been a long road. What?
178 days.
Well, you're the one that decided to drink and drive, so don't
Absolutely.
complain. You're lucky to be out.
Indeed.
So what you may want to do is call over to 14A4 to Mr. Heaton and see if there's a way of skipping this step, since it's the same court. If it weren't the same court, we couldn't, but because he has to be sentenced. But there isn't a reason in my mind, maybe there is, but there isn't a reason in my mind that Judge Freshauer can't do the sentencing and do the sobriety. I can't do it all at once. I don't. All right. Bond will continue. Thank you.
Thank you, Your Honor.
Burner, have a good one.
Good afternoon, Your Honor. Sylvana Reed, Assistant Public Defender with and on behalf of Ms. Williams. Would you state your name?
Tia Williams.
What are we doing?
Please.
I have a plea form that indicates that the defendant is going to be pleading guilty to 2 charges, larceny 200 to 1,000, both of those. I don't know what the height after that means, but she's pleading to those 2 charges. Both 1-year offenses. Upon her successful plea to that charge, count 1 and count 2 would be dismissed. Defendant agrees to pay restitution of $100, and there is a sentence agreement that she will be sentenced under HIDA. That's the court's full understanding of the agreement.
That is correct.
May I have her sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
State your name, please.
Tia Williams.
Ma'am, it is this court's understanding that you're going to plead to 2 misdemeanor charges. Is that your understanding? First charge, well, they're both the same charge. So count 3 and count 4 is larceny 200 to 1,000. Those are misdemeanors punishable by up to 1 year incarceration, a $2,000 fine plus court costs. Fine could be increased to 3 times the value of the property taken. If it's greater than $2,000, that becomes the maximum fine. You understand that?
Yes,
All right. Understanding that, you still wish to plead guilty
yes,
to the charge of larceny 200 to 1,000 as contained in count 3. How do you plead?
guilty,
To that same charge as contained in count 4. How do you plead?
guilty,
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
yes,
You signed an advice of rights form, is that correct?
yes,
Any question regarding those rights?
No.
Please look at paragraph 5 on that form. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
yes,
You understand you're giving up your right to appeal of right.
yes,
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
yes,
And also because you believe that you are indeed guilty of these offenses?
yes,
January 1st, 2025, at the location in Washtenaw County. What did you do that makes you think that you're guilty?
I made a transaction on a card that did not belong to me.
I'm
I
sorry?
made a transaction on a card that didn't belong to me.
Did you make just one transaction?
Yes,
Over the
Pardon?
2 transactions,
Say again?
2,
You made two transactions. So you had a car that didn't belong to you,
Yes,
correct? And then you attempted purchases or something
yes,
with that card. You did that twice.
yes,
Is that right?
yes.
Were they successful or was it just an attempt to purchase?
Your Honor, I believe that she was successful with the transactions.
Okay, so she was successful with the transactions. Were each of those transactions either for goods or services in excess of $200?
Yes,
And each one,
yes,
correct? Okay. You didn't have anybody's permission to do that, did you?
no,
All right. I think that's it. Ma'am, if I accept your plea, I need you to understand that if you commit misconduct as defined under the Michigan court rules between the time of the plea and the time of your sentencing, that the court would no longer be obligated or bound by any sentence evaluation or recommendation, and you would not be entitled to withdraw your plea. You understand that?
yes.
All right. Counsel, are there any other pleas, any other promises, threats, or other inducements which you're aware of which led to this plea?
No,
All right. And have I complied with the court rule?
Yes, Your Honor.
defense is also satisfied.
Court will accept the defendant's pleas to counts 3 and 4. Counts 1 and 2 are dismissed. The pre-sentence investigation and report is ordered at 14A1 probation. Sentencing will be
February 25th.
before me. Bond will continue.
Thank you very much.
Thank you.
In the end, the court wasn't interested in excuses. Sleeping in a car with alcohol in your system is already serious, but having a loaded firearm made the situation even worse. The judge made it clear that choices like these come with real consequences. What do you think about this case? Let me know your thoughts in the comments below.